Thank you for joining us today as we learn more about financial power of attorney. Financial power of attorney. Here's what a financial power of attorney looks like.
A successor agent is always recommended. If one isn't used, that section can be deleted. Please note that agents can always resign. A list of financial subjects is provided, so make sure the senior selects the subjects they desire or simply selects all preceding subjects. This list is not all-inclusive, so situations can be added if need be. If any protective measures are requested, they must be manually entered into the document. These can be included in the Special Instructions section. If the senior does not designate a conservator, you can delete that section. All unused sections can be omitted. We highly recommend that a conservator is named. The first notary block refers to the agent designation and can be filled in with the county where the document was drafted. The second notary block refers to the agent's acceptance of being appointed and needs to be notarized in the presence of the agent. Therefore, do not fill in the county or state unless the senior's agent is present. Make sure the senior signs the acknowledgement stating that springing versus non-springing language was explained. When determining an agent, ask yourself, would you trust this person with your wallet? If not, they may not be the best choice. Make sure all financial institutions have a copy of your power of attorney. It will do no good if financial professionals are not aware of the document. If the senior's wishes change and the document is revoked, revocation needs to be recorded with the county. Make sure that the senior knows about the Information for Agent section, that the section needs to be given to the agent and notarized in their presence. Some additions can make powers of attorney more protective. On the other hand, these measures could also make powers of attorney less effective. Some protective measures to discuss with the senior are springing power of attorney versus immediate power of attorney. Standard practice is to make the power of attorney effective immediately as to avoid any medical determination of incapacity down the road. The downside of doing this is it can open one up for exploitation and authorizes your agent to take actions for your behalf earlier than necessary. Another option is to use what is called a springing power of attorney. Under the effective dates section, state that the power of attorney authorization is effective upon the principal's medical determination of incapacity, based on 1 to 2 medical professionals. Often doctors are hesitant to give a determination of incapacity because of its implications, even if it is needed. It can be difficult to help a senior before they have been officially deemed incapacitated. Third-party accounting. Some people choose to name a third person on their power of attorney to keep track of the financial transactions carried out by either the principal or the agent. This way, they can identify unusual purchases or spending habits of both the agent, in case of financial exploitation, and the principal, in case they have been scammed or are losing capacity. Online banking is often an easy way for a third party to access the principal's accounts. But if it is not available, permissions can be sought from the principal's financial institutions in order to allow the sharing of financial information. Secondary signatures. Seniors can require a secondary signature for significant purchases made by the agent and/or themselves. The type of transaction that requires a signature can be customized to reflect the wishes of the principal. There could be a dollar limit, a specific type of transaction, real estate, a sale of personal property, or any number of situations that would require a signature. The signer needs to be a trusted individual or entity with an intimate knowledge of the principal's wishes. Limited powers. The principal can limit any specific powers. For example, the principal could forbid changes to beneficiary rights, beneficiary of life insurance, will, bank accounts, etc. The principal could protect specific parts of their estate. For example, they could forbid the sale of any personal property that is mentioned in the principal's will to ensure it gets to the intended beneficiary, or maybe forbid the sale of a special item that is sentimental to the principal. Powers of attorney are very customizable documents, and any number of steps can be taken to limit the power of the agent.
Thank you for your time today. Please be sure to call us at 406-444-7787 if you have any questions, or visit the link on the screen for more information.